Okay, ipatuloy natin ang ating pagbabasa-basa ng political law and international law. So, nandito na tayo sa topic number 8, citizenship. Ayan, so letter A, who are citizens? So, under the 1987 Constitution, Article 4, Section 1, it states that the following are citizens of the Philippines. Number 1, those who are citizens of the Philippines at the time of the adoption of this Constitution. Number 2, those whose fathers or mothers are citizens of the Philippines. Number 3, those born before January 17, 1973 of Filipino mothers who elect Philippine citizenship upon reaching the age of majority. And number 4, those who are naturalized in accordance of the law. Letter B, modes of acquiring citizenship. So, number 1, yung Filipino by birth. Meron dyan, jus soli at saka jus sanguinis. Hus yata yan, hus, yung pronunciation. So, Filipino by birth, letter A. Yung jus, gano'n na lang, para jus soli na lang, right of soil, which is the legal principle that a person's nationality at birth is determined by the place of birth. Example, the territory of a given state. And letter B, jus sanguinis, o yung right of blood, which is the legal principle that at birth, an individual acquires the nationality of his or her natural parents. So the Philippines adheres to this principle. Ayan. So yun yung unang mode, yung Filipino by birth, jus soli and jus sanguinis. And number 2, Filipino by naturalization, which is the judicial act of adopting a foreigner and clothing him with the privileges of a native-born citizen. It implies the renunciation of a former nationality and the fact of entrance into a similar relation towards a new body politic. So yun, dalawa yung modes, Filipino by birth, jus soli, jus sanguinis, and Filipino by naturalization. Letter C, pag-usapan natin yung loss and reacquisition of Philippine citizenship. Former natural-born Filipino who has been naturalized in another country who wishes to retain or reacquire their Filipino citizenship may apply for retention or reacquisition of the Philippine citizenship pursuant to RA 9225, o yun yung Citizenship, Retention, and Reacquisition Act of 2003. How about letter D, dual citizenship and dual allegiance? So under the citizenship clause of the Philippine Constitution, it is possible for the following classes of citizens of the Philippines to possess dual citizenship. Number 1, those born of Filipino fathers and or mothers in a foreign country which follow the principle of jus soli, right to soil. Pinanganak sila sa ibang bansa, isa sa kanilang mga magulang or parehong kanilang mga magulang ay Pilipino. So yun, following the principle of jus soli. Number 2, born in the Philippines of Filipino mothers and alien fathers if by the laws of their father's country, such children are citizens of that country. Number 3, those who marry aliens if by the laws of the latter's country, the former are considered citizens unless by their act or omission they are deemed to have renounced Philippine citizenship. Dual allegiance. Ano naman yung dual allegiance, on the other hand, refers to the situation in which a person simultaneously owes, by some positive act, loyalty to 2 or more states. So while dual citizenship is involuntary, dual allegiance is the result of an individual's volition. So ang dual allegiance ay voluntary. Magtungo naman tayo sa ating topic number 9, law on public officers. So, letter A, general principles. Public officers and employees must at all times be accountable to the people, serve them with the utmost responsibility, integrity, loyalty, and efficiency, act with patriotism and justice, and lead modest lives. So, ano-ano ba yung mga kinds of appointment? Yan, under the Act to amend the Civil Service Act. So, merong iba't ibang kinds ng appointment, yung non-competitive service, competitive service, at yung the exempt service. So, discuss lang natin briefly yung non-competitive service. Ito yung mga letter A, appointments by the President of the Philippines with consent of the Commission on Appointments, except provincial treasurers, chiefs and assistant chiefs and chiefs of bureaus and office and all other inferior officers of the government whose appointments are by law vested in the President. Appointments by the President of the Philippines with consent of the Commission on Elections. Letter A yan. Letter B, mga ano to ha, non-competitive service. Secretarial staff of the President, the Vice President, of the Senate President, the Speaker of the House, and each member of the Congress of the Philippines, including the personnel of all offices of the chairman of committees of both houses of the Congress. Hindi ako nagkakamali, ito yung mga policy determining, matataas na posisyon. Letter C, secretarial staff of each of the several head of departments and of each of the justices of the Supreme Court and Court of Appeals. Letter D, officers as may be required and chosen by the Congress of the Philippines in accordance with the Constitution. Letter E, members of the various faculties and other academic personnel of the UP and other government colleges offering courses on the collegiate level. Letter F, heads of departments created in charter of cities, secretaries of the provincial board or councils, and secretaries of provincial governors, city mayors, and municipal mayors. Letter G, permanent laborers, whether skilled or unskilled. Letter H, all supplementary employees in the Senate and the House of Representatives of Congress. Letter I, officers and employees appointed by positions for which the law prescribes specific special qualifications for appointment. Letter J, confidential, assistant confidential agents, investigation agents, and special and secret service agents. And letter K, commercial athletes. So non-competitive service are policy determining primarily confidential or highly technical in nature. Kaya mga permanent laborers, kasali rin sila dun sa non-competitive service. Number 2, yung competitive service shall include positions for appointment to which prior qualification or successful passing in an appropriate examination is required. Kung di ako nagkakamali, yung kailangan mo kunwaring pumasa ng LET na exam or kailangan mga posisyon na kailangan mo ng professional civil service exam. May RA something na required yung lawyer kunwari sa posisyon, mga ganun. And number 3, the exempt service. Ito yung mga letter A, elective officers. Letter B, members of the commissioned and enlisted service of the Army, Navy, and Air Force of the Philippines. Letter C, persons employed on a contract basis not exceeding 1 year, which may be renewable but not exceeding 4 continuous years, and those in government-owned or controlled corporations primarily performing proprietary functions with collective bargaining agreements, as well as temporary, emergency, or casual laborers. Pag-usapan natin letter C, disabilities and inhibitions of public officers. Sabi rito, individuals who lack any qualifications prescribed by law. Yan. Individuals who lack any qualifications prescribed by the Constitution. Yung mga losing candidates cannot be appointed to any government office within 1 year. Yan. Within 1 year from the election, kung ako nagkakamali. Elective officials during their tenure are ineligible for appointment to any public office or position. Yan. Appointive officials shall not hold any other governmental position. Tapos, there is no violation when another office is held by a public officer in an ex officio capacity. So, naalala natin yung sa mga commissioner, kunwari yung mga, there shall be an ex officio. Yun, wala raw violation nun. Yan. Lalo na kung they can't receive compensation or honoraria. Yan. So, walang violation yun. Pag ex officio capacity. Letter D, powers and duties of public officers. Public officials and employees shall at all times be accountable to the people and shall discharge their duties with utmost responsibility, integrity, competence, and loyalty, act with patriotism and justice, lead modest lives, and uphold public interest over personal interest. Letter E, de facto versus de jure officers. Yan. Yung mga de facto officers, there must be an office having de facto existence or at least one recognized by law, and the claimant must be in actual possession of the office under color of title or authority. So may meron siyang autoridad or acting under color of title or authority. Ang de jure officers naman, ito, is one who has the representation or appearance of being the officer he assumes to be, but who in fact under the law has no right or title to the office he assumes to hold. So ito yung mga intruder upon the office and assumes to exercise its functions without either legal title or color of right to such office. Ito yung mga hindi naman siya barangay captain pero kilala sa barangay tapos naghahari-hari sa isang purok. Yung mga ganyan-ganyan. Wala namang office or minsan they intrude upon the office and assumes to exercise its functions without either legal title or color of right to such office. Civil service, natalakay na natin yan. Ay, hindi pa ba? Mamaya na. Alam ko natalakay na yan sa constitutional commissions. Tungo na tayo sa letter G, accountability of public officers. So, discipline. Ito yung rules implementing the code of conduct and ethical standards of public officials. So, discipline under the rules implementing code of conduct and ethical standards of public officials. Ito yung mga grounds. Yan. In addition to the grounds for administrative disciplinary action under existing laws, letter A, pag directly or indirectly having financial and material interest in any transaction requiring the approval of his office, yan, accountable ka, pwede kang disiplinahin. Letter B, owning, controlling, or accepting employment in any private enterprise regulated, supervised, or licensed by his office. Conflict of interest kasi yan. Letter C, engaging in the private practice of his profession unless authorized by law or regulation, will not conflict with his official functions. Letter D, recommending any person to a private enterprise which has a regular or pending official transaction with his office unless such recommendation is mandated by law. Letter E, disclosing confidential information to further his public interest. And letter F, soliciting or accepting directly or indirectly any gift, favor, loan. Loan covers comodatum as well as guarantees or anything of monetary value. Yan. Pwede silang disiplinahin. Jurisdiction. Ano ba yung mga sinabi-sabi nating grounds? Yan. Ano ba yung jurisdiction itong rules na ito? Shall cover all officials and employees in the government, elective and appointive, permanent or temporary, whether in the career or non-career service, including military and police personnel, whether or not they receive compensation regardless of amount. So lahat pala halos, no? Letter C, dismissal, preventive, suspension, reinstatement, and back salaries. So any official or employee shall be punished with a fine not exceeding the equivalent of 6 months' salary or suspension not exceeding 1 year, or removal depending on the gravity of the offense after due notice and hearing by the appropriate body or agency. If the violation is punishable by a heavier penalty under another law, he shall be prosecuted under the latter statute. So administrative proceedings shall be under civil service rules. Yan. So any official or employee, pwede silang parusahan with a fine not exceeding the equivalent of 6 months salary, mabigat yun. Or suspension not exceeding 1 year. O dili naman ay removal. Letter D, condonation doctrine. O ano ba to? Condonation doctrine, also known as the Aguinaldo Doctrine, provides that a re-elected public official cannot be removed for an administrative misconduct committed during a prior term, since his re-election to office effectively operates as a condonation of his past misconduct to the extent of abolishing the right to remove him therefore. Yan. So parang yung mga kamalian niya na nagdaang term niya ay napatawad sapagkat siya ay hinalal ulit. Yan, condonation doctrine. So, magtungo naman tayo sa number 10 na topic natin, administrative law. General principles. Administrative law is the part of public law establishing the framework and determining competence of administrative authorities. Ito yung ini-establish na yung competence of offices of the government and provides the individual person with remedies in case his rights are violated. It is made up of laws which organize administrative bodies, rules and regulations issued by these bodies, and doctrines dealing with their creating, operation, and effect of their decisions and regulations. So, as a function, administration refers to the implementations of laws in non-judicial matters by competent authority. As an organization, it refers to the people controlling it for the time being. So, ano naman yung powers of administrative agencies? Parang marami silang power eh. Parang maraming powers sila. So, unang-una yung quasi-legislative power or rule-making power is the power to make rules and regulations which results in delegated legislation that is within the confines of the granting statute and the doctrine of non-delegability and severability of powers. So, quasi-legislative power ang meron sila dahil meron silang delegated power from the legislature. So, sa legislative power kasi, they have discretion to determine what the law shall be. and it cannot be delegated except for, yun na nga, yung mga nabanggit natin na quasi-legislative power, power to the local governments, yung mga ganon. So, ang quasi-legislative power na ini-enjoy ng administrative bodies only involves the discretion to determine how the law shall be enforced. And quasi-legislative power generally can be delegated. Yun na nga, it can be delegated by the legislative power. Hindi yung dinelegate na sa'yo, i-delegate mo pa, bawal yun. Merong doctrine doon, nakalimutan ko. Tests of delegation. Number 1, completeness test. Means that the law must be complete in all its terms and conditions when it leaves the legislature, so that when it reaches the delegate, it will have nothing to do but enforce it. Number 2, sufficient standard test. The law must offer a sufficient standard to specify the limits of the delegate's authority, announce the legislative policy, and specify the conditions under which it is to be implemented. So yan yung dalawang tests of delegation. Completeness test and sufficient standard test. So, nandito pa rin tayo sa powers of administrative agencies, quasi-legislative power. So, ano yung kinds of administrative rules and regulations? Number 1, capacity that administrative agency is acting in delegated power. Ayan. Number 2, what administrative agency is doing. So, ang dapat na ginagawa nila, they supplement the statute by filling in the details. And number 3, yung force and effect. Legislative regulations have the force and effect of law immediately upon going into effect, such as accorded by the courts or by express provision of statute. Requisites of validity nitong quasi-legislative power ng administrative agencies. Number 1, its promulgation must be authorized by the legislature. Ayan. Number 2, it must be within the scope of the authority given by the legislature. Number 3, it must be promulgated in accordance with the prescribed procedure. And number 4, it must be reasonable. So, yun ang ating quasi-legislative power. Meron din silang quasi-judicial power. Okay, dito naman tayo. Quasi-judicial power of administrative agencies. It is the power of administrative authorities to make determinations of facts in the performance of their official duties and to apply the law as they construe it to the facts so found. The exercise of this power is only incidental to the main function of administrative authorities, which is the enforcement of the law. Yeah, dahil meron silang quasi-judicial power, kaya nga may mga administrative hearings, administrative cases, meron silang administrative due process at meron itong requirements. So number 1, the right to notice, be it actual or constructive. Number 2, reasonable opportunity to appear and defend his rights and to introduce witnesses. Number 3, impartial tribunal with competent jurisdiction. And number 4, finding or decision supported by substantial evidence. Paano mo naman iaapila ito mga ito? Diba? Pag ayaw mo yung desisyon ng isang administrative body, under the executive order on appeal in contested cases, ito. Unless otherwise provided by law or executive order, an appeal from a final decision of the agency may be taken to the department head. Yan. Ganon umapila. So, magtungo naman tayo sa judicial review. And through petition for review. Ito. Agency decisions shall be subject to judicial review in accordance with this chapter and applicable laws within 5 days from receipt of the final administrative decision. Period. Otherwise, decision shall become final and executory. Shall be filed on the court specified by the statute. So, merong mga batas na ini-specify niya talaga doon kung saan ka, anong court ka pupunta. Pero ang sabi niya, by judicial review. So ayun, ulitin natin, nagdesisyon si administrative body, ayaw mo, dinala mo kay department head, ayaw mo, kinontest mo, yun, judicial review ka na sa court. Sa court kung saan in-specify. Letter C, administrative res judicata. Yeah. So res judicata refers to the rule that a final judgment or decree, hindi ko mabasa. Refers to the rule that a final judgment or decree on the merits by a court of competent jurisdiction is conclusive of the rights of the parties or their privy in all later suits on all points and matters determined in the former suit. Conclusive na siya. Administrative res judicata. So essential requisites. Former judgment must be final. Number 2, it must have been rendered by a court having jurisdiction of the subject matter and the parties. Number 3, it must be a judgment on the merits. And number 4, there must be between first and second actions identity of the parties, identity of the subject matter, and identity of cause of action. So once again, administrative res judicata, under their jurisprudence, the Supreme Court held that there are cases in which the doctrine of res judicata has been applied to judicial acts of public, executive, or administrative officers and boards. Normally kasi as a general rule, just res judicata sa ano lang sa courts lang. In this connection, it has been declared that whenever a final adjudication of persons invested with power to decide on the property and rights of the citizen is examinable by the Supreme Court, upon writ of error or a certiorari, such final adjudication may be pleaded as res judicata. So every time daw na may pagkakataon ang Supreme Court to examine yung desisyon ng isang administrative body, pwede raw siyang i-plead as res judicata. So ibig sabihin, kung hindi mo siya naiakyat, nadala sa Supreme Court, within the 15 days from receipt of final administrative decision, that decision shall become final and executory. Administrative res judicata. Okay, third topic, fact-finding, investigative, licensing, and rate-fixing powers. And powers pa rin pala ito ng administrative bodies, quasi-legislative, quasi-judicial, and fact-finding, investigative, licensing, and rate-fixing powers. So meron sila under that, number 1, enabling powers, those that permit the doing of an act, for example, issuance of licenses to engage in particular business. Number 2, directing powers, those that involve corrective powers of public utility, commission's power of assessment under revenue laws, reparations under workmen's compensation laws, and powers of abstract determination such as definition, valuation, and fact-finding. Meron din silang dispensing powers, which is the authority to exempt from or relax a general prohibition or authority from an affirmative duty. So ulitin natin, start tayo simula. Enabling powers, directing powers, dispensing powers, yung authority to exempt from or relax a general prohibition or authority to relieve from an affirmative duty. Number 4, summary powers, those that apply compulsion or force against a person or property to effectuate a legal purpose without a judicial warrant to authorize such actions. Examples nito, levy of property of delinquent taxpayer. At equitable powers, power to determine the law upon a particular state of facts. For example, power to appoint receiver, power to issue injunctions. Yan. So, mayroong mga ganyang power ang administrative agencies. Mapunta naman tayo sa mga doctrine na kinikilala, no? Pagdating sa administrative law. Doctrines of primary jurisdiction and exhaustion of administrative remedies. Doctrine of primary jurisdiction. This doctrine states that the courts cannot or will not determine a controversy which requires the expertise, specialized skills, and knowledge of the proper administrative bodies because technical matter of intricate questions of fact are involved. Relief must first be obtained in an administrative proceeding before a remedy will be supplied by the court, even though the matter is within the proper jurisdiction of a court. So, doctrine of primary jurisdiction ng administrative bodies in administrative cases. Ating ikalawang doktrina, yung doctrine of exhaustion of administrative remedies. Under this doctrine, an administrative decision must first be appealed to the administrative superiors up to the highest level before it may be elevated to a court of justice for review. Exceptions, purely legal constitutional questions when the administrative body is stopped, when act complained of is patently illegal, urgent need for judicial intervention, may pangangailangan ganon, claim is too small, irreparable damage, no other plain speedy adequate remedy, strong public interest, and if the subject of the administrative proceeding is a private land. So yun ang exceptions ng doctrine of exhaustion of administrative remedies. Kailangan magdaan ka muna sa lahat, exhaust mo muna yung lahat bago mo siya i-elevate sa court for review. Substantial evidence is the quantum of evidence in administrative cases defined to mean not necessarily preponderant proof as required in ordinary civil cases, but such kind of relevant evidence which a reasonable mind might accept as adequate to support a conclusion. So, substantial evidence ang quantum of evidence in administrative cases. Magtungo naman tayo sa ating 11th topic, election law. So, pag-usapan muna natin ang letter A, suffrage. Qualification and disqualification of voters. So, under voters registration decree, qualification ng voters, number 1, any citizen of the Philippines. Number 2, not otherwise disqualified by law. Number 3, 18 years of age or over. And number 4, resided in the Philippines for at least 1 year. in the city, municipality, or municipal district where he proposes to vote for at least 6 months immediately preceding the election. Ayan. So, yun ang qualifications niya. Section 5, disqualifications. Number 1, any person who has been sentenced by final judgment to suffer imprisonment for not less than 1 year. Such disability not having been removed by plenary pardon. Provided, however, that any person disqualified to vote under this paragraph shall automatically reacquire the right to vote upon expiration of 10 years after service of sentence. Unless during such period he shall have been sentenced by final judgment to suffer an imprisonment of not less than 1 year. So a person na nasentensya na makulong ng hindi bababa sa 1 taon ay disqualified. Yan. Number 2, any person who has been adjudged by final judgment by competent court or tribunal of having violated his oath of allegiance to the Republic of the Philippines. Number 3, insane and feeble-minded persons. Number 4, persons suffering temporary special disqualifications from exercising the right of suffrage in accordance with existing law. Ayan. So, medyo na-miss na natin. Meron pang maganda pag-usapan, registration and deactivation, inclusion and exclusion, local and overseas absentee voting. Yan. Para sa mga kababayan nating OFW, di ba, bumoboto sila sa abroad. And yung detainee voting. Yan. Bumoboto rin yung mga kapatid nating bilanggo. So, magtungo muna tayo sa letter B, yung candidacy. Qualifications muna ng mga kandidato for local officials. So, for local officials, number 1, Filipino citizen. Number 2, at least 23 years of age on the day of election for governor, vice governor, member of Sangguniang Panlalawigan, Sangguniang Panlungsod in highly organized cities, or at least 21 years old for said officials in component cities and municipalities. So, meron pa, pag 23 years old, pwede ka na maging gobernador pala, no? At least 18 years old for members of lahat ng sanggunian and punong barangay. Pag SK, 15 years old but not more than 21. Yun yung mga requirements. Filipino citizen, yung age requirement na nabanggit ko, able to read and write, registered voter in the constituency in the locality, and number 5, resident thereof for a period of not less than 1 year immediately preceding the day of the election. So, disqualifications, merong disqualifications under Omnibus Election Code, merong disqualifications as a result of election offense, and merong disqualifications under the local government code. So, tingnan muna natin disqualifications under the Omnibus Election Code. Number 1, those declared as incompetent or insane. Number 2, those sentenced by final judgment for subversion, insurrection, rebellion, or any offense for which he has been sentenced to a penalty of more than 18 months imprisonment. Number 3, those sentenced by final judgment for a crime involving moral turpitude. Number 4, those who are permanent residents or immigrants to a foreign country unless he has waived his status as such. Ito naman yung mga disqualification and as a result of election offense. Number 1, giving money or materials to influence or corrupt voters or public officials performing electoral functions. Number 2, committing acts of terrorism to enhance his candidacy. Number 3, spending in his election on amount in excess of that allowed by law. Number 4, soliciting, receiving, or making prohibited contributions. Number 5, other prohibited acts. Ito yung removal of campaign paraphernalia ng kalaban, regulation of propaganda through mass media, nilabag mo. So, yun yung other prohibited acts. Under the local government code naman, ito yung mga disqualifications. Number 1, those sentenced by final judgment for an offense involving moral turpitude or for an offense punishable by 1 year or more, imprisonment within 2 years after serving sentence. Number 2, removed from office due to administrative case. Number 3, convicted by final judgment for violating oath of allegiance to the Philippines. Number 4, dual citizens. Pinagbabawal under the local government code. Number 5, fugitives. Number 6, permanent residents in a foreign country. Number 7, insane or feeble-minded persons. So, meron ding mga magkakaparehas. Yung mga nakasuhan, yung mga natanggal sa opisina, convicted, mga nilabag ang oath of allegiance, yung mga incompetent and insane. Yan. Pag-usapan naman natin yung filing of COC o filing of Certificate of Candidacy. Ano yung epekto nito? So, under the jurisprudence, the Supreme Court held that appointive government officials who file their certificate of candidacy are considered as deemed resigned, while incumbent elective officials may run for an elective position without forfeiting their seats. Ayun. Letter B, substitution and withdrawal of candidates. So, under the Omnibus Election Code, substitution of candidates is allowed only in cases of death, withdrawal or disqualification of the original candidate, So in cases of death or disqualification, the substitute may file his certificate of candidacy up to midday of election day. However, in cases of withdrawal, yan, yung una kasi, sabi death, withdrawal, disqualification. In cases of withdrawal, yan, the substitute can only file his certificate of candidacy within the period fixed by the COMELEC. Substitution is not allowed for independent candidates. So, general rule. Pero pinapayagan ng substitution kung ang independent candidate ay tumatakbo sa barangay elections. So, sa ibang election, hindi allowed na mag-substitute ka para sa independent candidate maliban sa independent candidates in barangay elections. A cancelled certificate, ano to? Yon, a cancelled certificate of candidacy, void ab initio cannot give rise to a valid candidacy. Yan. Okay, nuisance candidate. Any candidate for any elective office who filed his certificate of candidacy to put the election process in mockery. So any candidate daw that will put the election process in mockery or disrepute or to cause confusion among the voters may be declared a nuisance candidate. Any registered candidate for the same elective office may file with the law department of the commission para ipa-declare mo yung kalaban mo na nuisance candidate dahil ang gugulo lang siya. So campaign, tungo tayo sa campaign. Ano ba yung premature campaign? Under the jurisprudence, the Supreme Court held that a candidate is only liable for election offenses only at the start of the election period. Kaya maraming hindi pa nagsisimula yung election period, gumagawa na ng premature campaigning. Number 2, prohibited contributions. Ito, under the Omnibus Election Code, no contribution for purposes of partisan political activity shall be made directly or indirectly by any of the following. Letter A, public or private financial institutions. Letter B, natural and juridical persons operating a public utility or exploiting natural resources of the nation. Letter C, natural or juridical persons who hold contracts or subcontracts to supply the government or any of its subdivisions. Letter D, natural or juridical persons who have been granted franchises, incentives, exemptions, or privileges by the government. Letter E, natural or juridical persons who, within 1 year prior to election, have been granted loans or accommodations in excess of 100,000 by the government. Letter F, educational institutions which have received grants of public funds amounting to no less than 100,000 pesos. Letter G, officials or employees in the civil service or members of the AFP. And letter H, foreigners and foreign corporations. Yan. So, nung nagdaang halalan, maraming ganyan pero hindi na parusahan. Ay, nako, mama. Okay. Pag-usapan naman natin lawful and prohibited election propaganda. So, under the Omnibus Election Code, lawful election propaganda shall include letter A, pamphlets, leaflets, cards, decals, stickers not more than 1/2 inches in width and 14 inches in length. B, handwritten or printed letters urging to vote for or against the candidate. Letter C, cloth, paper, cardboard posters 2 by 3 feet on occasion of meeting on occasion of meeting or rally should not exceed 3 by 8 feet. And letter D, all other election propaganda that is not prohibited by this code. So ito yung mga lawful yon, no? Basta may sukat siya. Pagka on occasion of meeting or rally, yung mga tarpaulin mo hindi dapat lalagpas ng 3 by 8 feet. Yan yung mga common Mga leaflet mo, dapat not more than 1/2 inches in width and 14 inches in length. Yan. Nakita na ako yan, usually sa barangay na abot nila. Parang resibo. Ito naman yung mga prohibited o pinagbabawal. Letter A, to publish, or distribute any poster, pamphlet, or handbill urging to vote for or against a candidate unless they bear the names and addresses of the printer and payer as required hereof. Letter B, to put up or display any billboard, tin plate poster, balloons in the like of whatever size, shape, and form. Kaya wala tayo nakikita mga ganyan, mga lobo-lobo. Letter C, to purchase, manufacture, accept electoral propaganda gadgets except that campaign supporters shall be allowed to wear hats and shirts advertising a candidate. Bawal brief. Letter D, to show or display any advertisement or propaganda for or against any candidate unless herein allowed. Letter E, for any radio, broadcasting, or TV station to sell or give free of charge airtime for campaign and other political purposes except as authorized in this code under the rules and regulations promulgated by the Commission pursuant thereto. So yung code na sinasabi niya ay election, yung election code. Yan. So, limitations of expenses. Ang dami pala nito mga election chorba nito. Limitations on expenses under the Omnibus Election Code. No candidate shall spend for his election campaign an aggregate amount exceeding 1 peso and 50 centavos for every voter currently registered in the constituency where he filed his candidacy, provided that the expenses herein referred to shall include those incurred or cost to be incurred, whether in cash or in kind, including use, rental, hire of land, water, or aircraft, equipment, facilities used in the campaign. Provided further that if the facilities and vehicles herein mentioned are owned by the contributor or supporter, the Commission is hereby empowered to assess the commensurate amount of the use thereof based on the prevailing rates in the locality and shall be included in the total expenses incurred by the candidate. So, required din ang statement of contributions and expenses. Under the Omnibus Election Code, every candidate and treasurer of the political party shall, not later than 7 days or earlier than 10 days before the election, file in duplicate, in accordance with the code, full, true, and itemized statement of all contributions and expenditures in connection with the election. Within 30 days after the election, said candidate and treasurer shall also file in duplicate a supplemental statement of all contributions and expenditures not included in the statement filed prior to the day of the election. So, dalawang beses pala magpa-file sila. Letter D, remedies and jurisdiction. Under the jurisprudence, the Supreme Court held that, number 1, the denial of due course to or the cancellation of certificate of candidacy is not based on the lack of qualifications but on finding that the candidate made a material representation that is false, which may relate to the qualifications required of the public office he or she is running to. Ayun, denial of due course. Petition for disqualification under the COMELEC rules on disposition of disqualification cases. The verified petition to disqualify a candidate for lack of qualifications or possessing some grounds for disqualification may be filed any day after the last day for filing of certificates of candidacy, but not later than the date of proclamation. Ang susunod na mangyayari doon, pag nag-petition ka for disqualification, yung petition mo shall be 10 legible copies with the concerned office. Ang dami-daming kopya yan. Number 3, failure of election versus annulment of election results. So ano ba ang failure of election? Under the jurisprudence, the COMELEC does not, ulitin natin, pag sa usaping failure of election. Under the jurisprudence, the COMELEC does not exercise its quasi-judicial functions when it declared a failure of elections pursuant to RA 7166. Rather, the COMELEC performs its administrative function when it exercises such power. The Omnibus Election Code was enacted to empower the COMELEC in the performance of its sacred duty of ensuring the conduct of honest and free elections. So ito yung provision na yun, Section 6, failure of elections on account of, if, yan pala yung pangit ng sulat eh. If on account of force majeure, violence, terrorism, fraud, or other analogous causes, the election in any polling precinct has not been held on the date fixed, or had been suspended before the hour fixed by law for the closing of the voting, or after the voting and during the preparation and transmission of the election returns or in custody or canvass thereof, failure to elect, and in any cases the failure or suspension of election would affect the result of the election. Yeah. The Commission shall, on the basis of a verified petition by any interested party and after due notice and hearing, call of the holding or continuation of the election not held, suspended, or which resulted in a failure to elect on a date reasonably close to the date of the election not held. So, nilipat nila yung date. Failure of election, lipat natin ang date. So, may kapangyarihan ang COMELEC na magtawag ng failure of elections. Yung annulment of election results naman, iba siya sa failure of election. Under the jurisprudence, the Supreme Court held that annulment of election result is an incident of the judicial function of the electoral tribunals. They only annul the election results connected with the election contest before it. It is done by the electoral tribunal only to determine who among the candidates garnered a majority of the legal votes cast. So, failure of election, COMELEC yan. Annulment of election results, ano yan, electoral tribunals. The Constitution grants the Electoral Tribunal with exclusive jurisdiction to decide all election contests before it, which necessarily includes fraud, terrorism, and other irregularities. Number 4, pre-proclamation controversy. Ang haba nito mga COMELEC na ito, no? Yeah. So under the COMELEC rules of procedure in pre-proclamation controversies, the Commission has exclusive jurisdiction in pre-proclamation controversies arising from national, regional, or local election. A pre-proclamation controversy may be raised by any candidate or by any registered political party, organization, or coalition of political parties before the Board of Canvassers or directly with the Commission. Ito yung mga issues that may be raised para sa pre-proclamation controversy. Letter A, illegal composition or proceedings of the Board of Canvassers. Letter B, the canvassed election returns or the certificate of canvass in appropriate cases are incomplete, contain material defects, appear to be tampered with or falsified, or contain discrepancies in the same returns or in other authentic copies thereof. Letter C, the election returns on certificate of canvass were prepared under duress, threats, coercion, or intimidation, or they are obviously manufactured or not authentic. And when substitute or fraudulent returns or certificate of canvass in controverted polling places were canvassed, the results of which materially affected the standing of the aggrieved candidate or candidates. At ikahuli, correction of manifest errors. Yan. Okay. Okay, so kung sumahin natin, failure of election, COMELEC. Annulment of election results, Electoral Tribunal yan. Pre-proclamation controversy, exclusive jurisdiction ng COMELEC. Ang election protest naman, Electoral Tribunal din ang pinag-uusapan. So under the jurisprudence, the Supreme Court held that an election protest pertains to the casting and counting of votes and is concerned with the issue on who actually received the majority of votes. It refers to an election contest grounded on fraud or irregularities in the conduct of elections, the casting and counting of ballots, and the preparation and canvassing of returns. The issue is who obtained the plurality of valid votes cast. So the real party in interest is the one who would be benefited or injured. Yan. This can only be filed by a candidate who has duly filed a certificate of candidacy, normally yung losing candidate. Pero as to the substitution in election protest, normally yung kalaban mo, yung nagpo-protesta, the Supreme Court allowed a vice mayor to substitute for the protestant in a situation wherein the latter died during the pendency of the protest, because if the protest succeeds and the protestee is unseated, the vice mayor succeeds to the office of the mayor. Succeeds to the office of the mayor that becomes vacant if the one duly elected cannot assume office. However, substitution by the widow of the candidate was not allowed since the widow is not a real party in interest. Yun yung kaso ni Fernando Poe versus Arroyo. So, ito yung huling topic sa COMELEC. Yung quo warranto. Quo warranto is a special form of legal action used to resolve a dispute over whether a specific person has the legal right to hold the public office that he occupies. The regional trial court shall have exclusive original jurisdiction over all election contests involving elective municipal officials. Pati yung sa barangay, MTC yan. Yung Senate Electoral Tribunal naman, any registered voter who seeks to disqualify a member of the Senate on the ground of ineligibility or disloyalty may file within 10 days from the proclamation. Yan. Ulitin natin, quo warranto is a special form of legal action used to resolve a dispute over whether a specific person has the legal right to hold the public office that he occupies. Ulitin natin, the regional trial court shall have exclusive original jurisdiction over all election contests involving elective municipal officials. Pag barangay officials naman ang pinag-usapan, MTC naman. Ayan.